Is it? Anybody in the back got one?
Yeah, as far as I know that, as far as the private property and all that, you can't carry a gun. So only with, like, say that Toys R Us has a sign on there, and I carried it in there by chance, maybe I forgot I had it or I was running it real quick. Am I legally liable, or is it more trespassing?
You're not breaking the law. You're only breaking the law. There's no. They can ask you to leave. Now, if you become persistent, tell them you're not going to leave, make an issue out of it. Then you could get a little bit of a trouble. You know, the law enforcement has to come here and remove you or something. But you're not violating the law. Yeah.
So it's trespassing.
It'd be trespassing.
Okay.
What I'm hearing. Yes, sir.
In some states, however, Ohio's one. If they posted it in its conspicuous notice, it's a different analysis. There's an Ohio penal statute that says, and I'm just making a point, so as you go across state lines, it changes dramatically sometime. If you drive across state lines, if you were able to legally carry there, and there was a sign that says no, I've got a picture of it. Once you pass that point, you're committing a crime if you're caught. It's not like they can ask you to leave.
So yes, sir.
In the issue of deadly force in the commission of a felony, suppose I'm at a Meijer store, CVS, or Walmart.
Okay. The question is about use of deadly force in a forcible felony situation, but you're not the victim.
Right. I'm at Meijer or wherever.
And somebody's doing.
Guy walks into the pharmacist and shows a weapon and starts to rob the pharmacy.
Okay, somebody's robbing the pharmacy.
And I'm armed.
All right.
I guess at what point, the idea of deadly force, do I just allow him to rob it and hope he doesn't shoot somebody? Or at what point am I allowed to draw my sidearm and confront him?
Okay, so I guess the question is, are you allowed, at what point you're allowed to? And I'll add another one to it, is there any obligation to do so?
The answer to that, in Indiana, I'm told I wasn't speaking up loud enough. In Indiana, you have, and again, it's going to come down to what's reasonable, you have the right to use self-defense to protect a third party. Now, you get some real weird wrinkles. If that third party you think you're protecting is part of the crime, it can get funky, but you have the right to defend a third party yourself. Whether that's reasonable or not, I don't know. Whether do you have a legal obligation to do it? No. Do you have a moral obligation? That's a question you'll have to ask for yourself. There is, though, a statute in Indiana that if you're requested by law enforcement or firefighters to assist them and you don't, you commit a misdemeanor.
So in the case of that, if the guy started shooting people at that point, and I decided I'm not going to draw my sidearm, so I might shoot somebody else, and they found out later I had a sidearm and I could have done something, I can't be prosecuted for not
that's a moral question. That's not a legal question. But again, it has to be a forcible felony. Make sure that distinction's in there.
The example that I use in the class is on that is suppose you're walking down the street, in the evening, Fort Wayne, wherever it is, and you see some big guy on top of a little guy, and he is just crunching on him, man. He is wailing on this guy who's screaming for help, and so you pull out your Glock and cap the big guy. Turns out he was an undercover drug agent and taking down a major drug dealer. So, oops. Yeah, oops. Yes, sir.
I just wanted to go back to one thing you said about the Ohio laws, that how different they are here. Yeah, in Indiana, if you, an owner of a restaurant, or I work in hospitals and in radiation oncology, I carry because I've done places like Gary and other places like that. If they taught us in the Utah non-resident class, if you go into Ohio and there's a sign that says no firearms, they will actively arrest you. And you don't always see them. I was just there in Cincinnati just the other day. I left the hospital. I looked for it when I walked in the door. There was not one in evidence, but when I finished the day up, I came out to a side entrance and was on the glass door on the side. So legally, it's posted. So look really well because they've been taking minutes to throw cuffs on it.
2 points on the gentleman that mentioned, can you use defense for a third party? And somebody else mentioned I think Bob did, taking a bad guy down. If you want to realize how confused up and screwed up a shootout can get, read the FBI Miami shootout.
April 11, 1986.
They don't know who to shoot. I mean, no one knows who the good guys are or the bad guys. And if you ever want to read a fascinating account and learn something from it, that's a great learning tool. Under federal law, and I wish Indiana, or not Indiana necessarily, but some of the other states had it, under federal law, we're talking about Ohio, it has to be conspicuously posted under federal law, meaning it's, if you happen to go into a door of a federal building and you know it's a federal building, you're making a mistake. But if you stumbled into a federal building without a conspicuous posting, it's a defense to the crime of carrying a firearm onto federal property.
Yes, sir.
If you're arrested, I understand that you get a phone call to call your lawyer. I have heard that you need to have the business card of the lawyer because you will not be allowed to look through your cell phone to retrieve a number. Is that true or false?
I'd say your cell phone's going to get confiscated as evidence, probably.
And theoretically, so would your wallet, but they would give you a card as opposed to giving you free reign over your phone for.
That's gonna. Yeah, sure. I'm getting tired. I had to work last night. Yeah, I want some. That's gonna be between officer to officer, jail to jail systems. Okay. Standard is usually they confiscate your phone. I know when I arrest someone, if they want a phone number for an attorney, whatever, I don't care. Either way, it's gonna happen. So I'll just right on. I figure if I help them, it's more compliant they are. So the booking process, I don't have to deal with. We're not going to piss and moan all through booking. Some jails have no problem with that. They assist. Some have very strict policies. Phone's confiscated. You run this process. There's a phone on the wall. You figure it out. So it differs. It's not a set standard, if that makes sense.
Yes, sir.
Are we going to discuss the topic of reciprocity between states?
Okay. Anybody? We need another week's worth of food here.
Oh.
Yeah, we can open up that can of worms to some degree, and we can start with Indiana, as in what states recognize the Indiana permit, what don't, how you go about it. Anybody want to step into that?
You've got a card that's floating around. As I mentioned, I get calls from. Typically they're emails, but emails from law enforcement all over the country. They're coming to Indiana and want to know because under HR 218 they have to follow certain state laws. I always said I would never do a 50-state guide because it's impossible to do and not make it meaningless. I actually figured out with technology you can have hyperlinks. So if you get to the 90% of the questions answered in paper or online, but you've got an oddball question, for instance, you have a Glock 18 and you have a federal stamp for it, you could take it to another state, but you'd have to have ATF's approval for it first. So I have all the hyperlinks on there. June 1, that's coming out. Reciprocity is one of the most complicated, problematic areas there is. Even in Indiana, I'll give you a couple of examples. Indiana statute says we'll recognize all other licenses unless you're a resident. We'll recognize all other licenses and all foreign countries' licenses. And I always envision some. They're on the unfavored nation list, so I can pick on them. I pick on equal opportunity to pick on her. I always manage some North Korean sitting on the side of the road saying, "Here it says in this language I can carry a gun here." Indiana recognizes them all. Indiana's is not recognized in a number of states for 3 reasons. One, the lifetime license doesn't have an expiration date, and some of the states require an expiration date. Secondly, there's no photo ID, so in those states that recognize Indiana, you have to have photo ID to go with it. And thirdly, Indiana doesn't have a training requirement like a lot of the states do. So for instance, Pennsylvania won't recognize Indiana's unless we were to have a level of training consistent with what they require of their citizens. The reciprocity is something that, even though I'm doing a book on it and a website, it's something you still have to do it right before you go because it changes and it's that technical and that specific. For instance, Utah and Florida are prolific non-resident license issue states because they probably make a lot of money on it. And now they're in some sort of tiff over non-resident licenses and are potentially not recognizing each other's because they're both competing for it. And then Alabama has said, we won't recognize, or the Attorney General has at least raised the question of not recognizing a non-resident license for purposes of carrying in that state. If you're trying to circumvent your own state's limitations, Alabama's raised an issue of whether they're even going to follow it or not. So it's not for the faint of heart. It can be done. I'll say one more thing on reciprocity, because it's something we could spend the rest of the day talking about. And I literally spent 2 weeks between Christmas and New Year's hiding in a hotel room writing this book on reciprocity. But the other point to make, and it's a very important distinction, no matter where you're talking about a gun, whether it's a handgun or a long gun, as long as you're going from one lawful place to any other lawful place, if the gun is not in the passenger compartment and it's disassembled and the ammunition separately and it's locked and not accessible to you, you have a federal right, despite what any state might say. You can go, I'm not recommending this, you can go right through downtown Chicago with the banner on the top of your car saying, I'm on the way to Wisconsin with my AR-15 in the back. Don't call me, that's an example. You have an absolute right to do that, but it took the Department of Justice writing some of the New York agencies to get them to follow, because they confiscated at least one gun at JFK for people moving in between two lawful places. So it's not for the faint of heart. It can be done, but you've got to really think about, I even talk about state boundaries. When you're in one state going to another, it can get really nuts. You could, if it's handgun only, you could drive up to the state line, go into a state that's not a state that's reciprocal, take it apart, put it in the trunk, drive to the next state line that is reciprocal, take it apart and carry it. But it gets really goofy, so think through it if you're going to do it. Or if you're on a border, area like Senator Tom's is, you can be what, in Illinois, Kentucky?
Illinois and Kentucky.
Illinois and Kentucky. And probably people that are doing that route are probably doing meth. It's still A-dub things.
I want to also, if I can, really follow up on that too. On that reciprocity, just at the federal level, to be honest with you, my own opinion is an opinion. I don't think it'll ever happen, because I don't think we'll ever get that many cats together and agree on something. And I'd like to, wish it would happen. I don't think it will. But on reciprocity in Indiana, about the aspect of our license is not recognized in some states because we don't require training. Just from a citizen standpoint and a legislator standpoint, I don't want that. I recommend people learn the use of firearms and become very familiar with it. It should be second nature to them if they're going to carry a handgun. I fully understand it and recommend training. But the requirement of requiring it, when you do that, in my opinion, you set the government up to start initiating fees and requirements that maybe become so expensive it's unaffordable. It can happen. I mean, that's the propensity of government to do this. If they can't legislate it out, they can price it out of your reach. And that's what I'm worried about. So I would not never support requiring citizens to have training to obtain a handgun or a handgun license. And on that aspect. And then also, somebody mentioned a while ago, and I get this asked of me a lot, on our license, it is a cheesy piece of paper. It's flimsy. And Sam Adams would have absolutely stroked out if he realized that this country was going to require you to have a piece of paper to exercise your Second Amendment right. Yep. But some folks have suggested putting an endorsement on your driver's license. I would not ever support that either, because when you put it on your driver's license, for sure you're professing that you maybe have a handgun with you. If you're traveling in a state like Ryan was talking about, that's not reciprocal, maybe it's the state of Illinois, which is a very toxic state, and you're pulled over, you have to hand your driver's license over, the cop stops you for blowing a stop sign, and right there you're advertising you probably have a gun. I just don't want to put ourselves in that kind of jeopardy. So those are things just along the lines of reciprocity that keep in mind.
Before we get, I just want to hit a couple things on this one. In Ohio and Indiana, it's big. I mean, everything's a big can of worms. The reciprocity language in the Utah, Ohio, and the reciprocity language in the Florida, Ohio, is boilerplate generated by the state of Ohio, and it's very clear if you have a Florida or a Utah permit, you don't have to be a resident of Florida or Utah to be able to carry there. The Arizona permit, however, there's a sentence buried in the reciprocity agreement that if you read it, it tends to want to say, it can be interpreted, that you have to be a resident of Arizona. I had an extended conversation with the Assistant Attorney General of the state of Ohio, that's at OPATA, the Ohio Peace Officers Training Academy, assigned there, and he's the go-to guy. And he didn't know about it. He said, yeah, that seems to be what it's saying. I said, okay, well, how do you interpret it? Well, if anybody asked me, he said, I'd say it's okay. So, you know, what do you do with that kind of stuff? Also, the most up-to-date website, maybe somebody can correct me, that I know of at this point, I haven't seen Brian's yet, is www.handgunlaw.us. And this guy keeps it updated the most. The other one you mentioned was the federal thing, H.R. 822, that did pass, and then the Senate bill, which, you know, who knows. And then we had conversations on the enhancement. I'm not even going to open that can of worms. Okay.
Not to endorse a particular solution, but on this little phone here, I have an application called CHL Reciprocity. And you can go in there and you can see which states honor which other states' laws. And then if you have individual questions about the state law, there's a link to the state's website.
Yeah.
That you can take a look at.
Are you on Android or iPhone?
I'm on an iPhone here. But I think they,
Well, that was the thing with Ohio, because if you look at the Ohio reciprocity list, it lists Arizona with no asterisk, no qualifications. But if you dig deeper and it does list, you can go to the reciprocity agreement and read deep in the reciprocity agreement. You get this thing that seems to want to say you have to be a resident of Arizona, but then the assistant AG talking to me, and this is hearsay for you, said no. And if a cop ever asked him if it was okay for an Indiana resident with an Arizona permit to carry in Ohio, he would say yes. You go to handgunlaw.us and he says no, you can't. Sir?
That sounds like the net of that is, if you're going to travel in your motorhome or something, you better not take it with you. Is that the way that finally nets out?
Grizzly spray. Just saying.
He's sold. Are you sniffing that stuff again?
you're taking it into Canada.
You got stock in it?
I was looking for. Anybody have a good want to respond to that answer? I mean, to that question of just shouldn't take it with you if you have a motorhome.
2 weeks ago, because I'm a glutton for punishment, I made it 3 weeks in a row by coming here last weekend, but I was in Elkhart for the gathering. Basically, it's a National RV Association, and we had some of the same discussions. You put it on the outside, and then what happens if you travel into Canada? If it's the right kind of gun, and you're going to, even a handgun, and you're going to leave it with the right length barrel at a sporting club, you can. You get beyond the U.S. border in Canada, it's getting really complicated to do. But an RV gets really complicated because if you have here's what came up last weekend. This particular gentleman had given up any residence. He didn't vote. I don't know what he did with his driver's license. I said, what's your driver's license say? He had nowhere to come from to go to say he's lawfully leaving his place of residence to go somewhere else. He just perpetually drove around with his wife. And I'm like, that's a total brain bender. If it's a reciprocal state, you could carry a long gun there, or a handgun there. If it's not a reciprocal state and there's not a separate compartment, then it's going to have to go on the outside or something to that effect. But they had some really interesting questions as RVers about guns. And I came back to the issue of, if you don't know, is it worth sitting in federal state prison when there's so many good alternative weapons? Grizzly spray is a great one because you get the fire extinguisher size. And recognize, though, some states still have some oddball distinctions on pepper spray and the ages for those. The other thing is, though, even something as simple as carrying a Ziploc bag full of sand and having that in your pocket, you can repel a pretty aggressive aggressor with a handful of sand in their eyes to buy yourself some time. That's the kind of crap I think about when I'm so no fun to travel with.
My question is about training. You guys mentioned it.
Training.
But more how that, if you do a fair bit of self-defense, pistol type training, how does that affect your, assuming you've just been through a deadly force incident or whatever you want to call it, how does that affect your legal defense, or how could the prosecution use it? How's it good or how's it bad? Is there a too much? Say you do 3-4 classes a year, suddenly you've got 300 hours of training. Is that going to come up as whoa, this guy does this all the time, or is it going to be a good thing specifically from a legal defense, prosecute whatever in the courtroom type of standpoint?
Go ahead now.
The question is, can you overtrain to the point that it gets crammed down your throat if you use deadly force? I would say you are an anomaly in doing that, but that's great. I don't see that being an issue because you're not going to do and be involved in a deadly force encounter anyway, because a big part of the training is not being in a place where you need to use deadly force, and you're not going to have sympathetic squeeze on a 4-pound 1911 trigger and shoot somebody you don't intend to. My belief is, to a reasonable certainty, the benefits of training way outweigh the deficits, if for no other reason than it'll let you make a judgment call that if you're, for instance, you've made the call, you're going to use deadly force, you're not going to, I'm not picking on the police here, but they're the only ones that we get to see the shootouts. There are lots of shootouts where nobody gets shot, but lots of bullets get fired. You won't miss and hit somebody you don't intend to hit either. So I think it can get spun either way. From a criminal defense standpoint, if it's a close call, the prosecutor could cram it down your throat, but that's assuming they know about it, which is why from a defendant standpoint, time always aids defendants and information control always aids defendants. But I would take the problem that you have every day of the year versus the problem that comes with not being skilled enough with the firearm. That's my view, and I think how it could get spun either way.
Sure. I have a follow-up question to that. Or let's get another response.
Well, I was just going to say, as the lawyers, we'll spin it any damn way we want to. If I think you overreacted as a prosecutor, I'm going to try and spin your training against you. That being said, there was a question during the break to me and to Chief here about, well, if someone comes in my home, what am I supposed to do? Going back to that whole situation. The more training you have, as Brian just said, the more you're going to think at a lot quicker pace, and the more you're going to respond and know what response you're going to have. It's like the quarterback. You got 3 seconds to get rid of that ball. The more you do that and the more training you have at doing that, the better you are at doing that. So if you are in the training and part of that training is to avoid those situations, that's wonderful. But once you're in that situation, if you are better able to articulate why you did what you did, that training has just paid itself over and over in gold. Because then you can say, I took my gun out for this reason, I discharged it for this reason, and I aimed for the largest part, the center of mass. That's what I've been instructed to do throughout. And I've taken classes for 20 years telling me that. As a prosecutor, that's difficult for me to counter. So I think you are an anomaly as well. Probably everyone in this room is an anomaly compared to what we usually see. You had a follow-up.
Yeah, just a quick question, because in many of the places that you're taught, they always teach the double tap. And earlier you said, well, I'm going to spin that with a second shot. So does that negate that by saying I've spent thousands of hours of training and I'm taught to double tap? That's why I put 2 in this load.
If you can articulate that and even bring in experts, it makes my job as a prosecutor tougher. But the jury that I am addressing as a prosecutor, I'm going to play that. If you don't tell me that, I'm going to play that up all the time, a second shot. And part of it is, as we review the physical evidence, where did that second shot, how did it enter, what's the trajectory, and what's the eyewitness statement, what do you say? And that's what Brian says again, and I'm going to put my defense attorney hat on, don't say anything until you've had time to reflect, talk to your attorney, because if you say, he came at me and I shot this, and then 30 seconds passed and I shot him again, but by that time he's down on the ground, you're in trouble, obviously. So I think you can counter.
There's a difference between when that shot occurred.
Exactly.
Say, look
right.
First, think later.
Right. I told the story outside. I went to a crime scene when I was a young deputy prosecutor. It was a home invasion. The ex-husband literally busted in the back window of the home, and the husband and wife heard it. They both had handguns at the side of their bed and their night tables. They pulled him out. She picked up the phone to call the police. The phone line was dead because the ex had cut the phone line before crashing in the window.
When we got there, the dead man was in the doorway to the bedroom with a big old butcher knife that he had thrust into the door, threatening them, and several marks in the door, and he had about 10 slugs in him because both of them had just unloaded on him. All right, you know, they didn't ask questions. He came to the door. They went, "Oh, that's what that was. The phone line's dead. We're not calling the police. We got kids. Clean shoot. No charges. Go home." So, yeah, it varies.
An exception to that, only because I've taken a lot of these non-resident license classes. In non-retreat states, judges, juries, and prosecutors get all hung up on subsequent shots, even if they are in a quick succession. They can get down and say the first two were clean shots and then micromanage that the split second later the third shot wasn't right, which is again is the reason to don't say anything and get yourself a defense attorney that can help you unpack that story.
Yeah, I've got a question. You say don't say anything, but if you're in a situation, officers show up, what do you do? I mean, if you're not saying anything, you are not cooperating. You're immediately handcuffed and in jail, right?
All right. As much as this just rubs me wrong to say this.
Stand up.
Yeah. Don't film this. The best thing you can do is as soon as you're at the scene and the first question that comes over is say, I want to talk to an attorney. Yeah. And it's pretty much done. Usually what we'll do is we'll say, well, listen, that's fine when I Mirandize you, but right now we're just developing the investigation. I need this information. Do you see what I'm saying?
Yeah.
So,
I mean, you want to tell them, hey, the guy just broke in my door.
Yeah. I'll put it to you this way. You say nothing, you know, and you know it's going to agitate us somewhat. And we're going to want information. Hey, we're just trying to, you know, I just need to talk to my attorney. And if you say it enough, we're going to get a little nervous because now we're starting to pound it in. Then we're going to start to think about Miranda in case, you know, we're going to file criminal charges obviously on this or send something to the prosecutor, and the prosecutor's pissed because I just worked you over for an hour after you asked for an attorney. And he's going to be like, what are you doing? Let me handle this. And he's right, you know. So at that point in time, it's done. But it's no different than, for example, I got these two gentlemen's cards. If I make a shoot as a sniper, my department's going to do an investigation, correct? The first thing I would say is, I need to talk to my attorney. Now, they have a special law in which, if there are filed criminal charges, I have to answer. What's that, Purdle? I don't know. Well, anyway, there's a term for it, and they can actually, I have to answer. But of course, then I can't be held. Garrett. Yeah. Then I can't be held criminally, I believe. Does that answer your question? So, you should ask right away.
Now, what about the 911 operator? Let me qualify and back up to what you said. Don't confuse that with basic, following basic commands, providing basic identification issues.
You
cannot refuse to provide your name to a law enforcement officer, and you don't want to be not saying anything if you're waving the gun around when they're pulling up. You want to say that because you're going to wind up in the casket next to the guy that probably is going to be there with you. So there's a difference between informational, giving information versus basic instructional and complying with lawful law enforcement commands. And any seasoned prosecutor or defense attorney or judge or lawyer will tell you, even though it's incongruent with personality to talk to not talk, if you're talking and your lips are moving other than giving identifying information, you're making a mistake.
Call? I've never understood this. Why don't you call an attorney at or near the time you call the police if you got a real issue? I'm not trying to be sarcastic, not trying to be facetious, but even my clients that are really bad people, why the hell didn't you call me? You know, if there was a question or an issue, call the attorney. You know, and the attorney can be there. You see on TV where the attorney shows up at the police station damn near at the same time that suspect's brought in? That can happen in real life. But it's never happened to me. I don't know if it's ever happened to Brian, but, you know.
I'd never see that.
I think it's because it kind of implies that you've done something wrong, like you're guilty of something.
That doesn't matter.
You know, even if it's a justified self-defense shooting, I did everything right. What do I need an attorney for? I didn't do anything wrong.
I have had countless clients as a defense attorney come into me after they've spoken to the police and said, Bob, I spoke with them because I had nothing to hide. That's great. You've just bonded out, you're charged with a heinous offense, and we have to tell the jury that. It didn't stop them from arresting you. Just say, this is what I want to do, I want to talk to my lawyer. Even though you have nothing to hide, you have time. What you've done is you've bought yourself time, as Brian said this morning, to reflect and make certain that you're not just babbling. Okay. Right. In the civil side, too, it all can be used. If you are sued civilly by someone, even though the prosecutor or the police have declined to file any charges against you, you could face a civil lawsuit. All of what you said at any time to anyone is going to come in. I go so far as to tell my clients, once they met with me, you don't talk to anybody else about this. I don't care if your wife, your husband, your brother, your sister, your mother, your father ask you, you don't talk anymore about it. You're done. You shouldn't have talked to them that night about it.
Let's say you're involved in an encounter, and I'll classify an encounter as maybe pulling your weapon and pointing it at somebody in an effort to stop an attack, or actually firing a weapon. And there are no police around, so you have to call 911 as a responsible citizen. What do you say to the 911 attendant?
From the encounter?
Yeah, I just pulled a gun on somebody who was threatening me with a knife, and he ran off.
Okay.
Well, I pulled my gun and pointed it at somebody, so I feel like I need to let somebody know, because that guy could go and report me as a criminal for having drawn down on him. Or the other situation would be that I actually pulled the trigger and there's now a wounded or dead person in the street. I can't just leave the scene. I have to call 911.
That needs an attorney.
And on the first example, these are the question, and again, these are the questions with the answers, and the questions are all right to a large probability. The slightest fact can make all the difference in the world. But the general question was, first off, if you discharge your gun, do you call and make a 911 report because you have some duty to do that? There may be an independent duty, and there could be some odd, obscure criminal provision, but you also have an absolute right against self-incrimination, and that'd be making an incriminating statement. So if somebody's going to call the police, let it be the other guy that's there. And the second question, one more time?
You pointed a gun at somebody who had pulled a knife on you, let's say, and they get scared and they run away. They stop the attack. Then they go home and call 911 and say, hey, there's a crazy man out there pointing the gun at me. Well, I feel like I need to preempt that and call and say, here's what happened, so that I won't be charged with reckless endangerment.
And in domestic violence cases is an analogous area. Sometimes the person, particularly if it's the female calls first, it comes down to whoever calls first wins in the tit for tat. I wouldn't necessarily make that assumption and call and think that you're making a statement to preempt that person from doing it for a couple of reasons. One is the other person might not do anything. The second reason is maybe that particular person or makes the statement, you don't, and because you haven't said anything, like the Central Park, there's one person in Central Park rape years ago who never ever talked. That's the only person that wasn't convicted. You may well be giving a statement that you wind up both being criminally charged for doing something, one criminal recklessness or pointing a firearm, and the other person for whatever it was they're doing to cause you to do that. So if you're going to make that call, you might as well call an attorney. But in the absence of any clear guidance, always not talking is always the right call. Not talking and the passage of time always benefit defendants. You got anything different?
I second that wholeheartedly. And if you do feel obligated to call 911, I would simply say, I need the police here. Well, tell me what happened. I'll do that when they get here. You know, I don't see any obligation you have to give them any more information. Why do you think I called 911? You know, to sit down and chew the fat? No, I need the police. I need someone here now. And if you can say, you know, someone's shot, someone's injured, fine, but I wouldn't offer anything more.
With this whole recent incident in Florida, stand your ground laws have really come into light, pros and cons. Does Indiana have a stand your ground law? And from kind of you guys, all of you guys, what is your general guidelines that you would say these are the goods, these are the bads?
We do have a stand your ground law. It's a council doctrine was signed in 2006. And I'm not sure how it looks like it's similar, and these guys probably answer, but it does look like it's very similar to what Florida has. And I think, in fact, I believe Indiana modeled after Florida's law, didn't he? And our stand your ground law, our council doctrine in Indiana, was it was curious. When it was passed, and we were there when the governor signed that into legislation, or into law, there wasn't any repercussion. No, I didn't hear anybody outraged about it at all. But last year when the Supreme Court made their ruling in the Barnes case down in Evansville, they opened that all up again, our castle doctrine. And so this past session, we had Senate Bill 1 that was introduced to address the issue about law enforcement entering a home unlawfully. And that's what the ruling was with the Supreme Court. And so I think in Indiana now, the way we've and they tried to, Senator Mike Young had that bill, and he worked very hard to try to frame that amendment, or new law actually, to the benefit of the homeowner as well as those in law enforcement that would be involved in investigating the crime or chasing a criminal that would come into a house, or they had reason to come into a home. And so I think what we have now is pretty well written, but I know just listening to these guys talk about, legislatures write laws, and these guys usually defend them or fight for them or against them. I don't know where the cutoff is on this. For me personally, I kind of wish we didn't have laws at all. We just had a few rules, because I think rules work a lot better. In basketball, when you step out of bounds with the basketball, the rule is you give the basketball up. It's not arbitrated. It's not plea bargain. There's no defense. It's just how it is. And I know that just listening to the discussion today, you can see the litigation that we have because of all the laws, and because of a law, and maybe it's prosecuted, and as a result of the prosecutions or the defense or whatever, there's new laws that surface as a result of that, and we just keep drowning in more laws. And I don't know what the answer is on this, but we do have a stand your ground law in Indiana, and I think it's what we have now is well written. I think it protects those in law enforcement as well as the homeowner. But it did generate a lot of controversy in this past session. I got a lot of emails as well, but a lot of legislators did from those in law enforcement who kind of, I think, had the perception that this was a law that was unfavorable to them. But I don't think that was the case. I think it was to the benefit of everybody. But maybe Mike has something to say about that.
I don't know if you want to know what the law enforcement community thought of that. That law is a little hard for us because it does mention a peace officer. I believe that's the verbiage.
Well, actually, Mike, it doesn't even use the term peace officer. It uses the term statute number that you go to, and then
it defines the peace officer. Law enforcement, we're not against you protecting your homes or anything, but it included us. And if we were to do something I think is in violation of felony or something, where I was concerned about the law is there's exigent circumstances in which an officer can enter your home without a search warrant, and that was my biggest concern with the law. So, and a perfect example is welfare checks. What are welfare checks? Your family calls and says, I haven't heard from grandma in weeks. I actually did one in which there was a note. I'm sorry. There was a note inside the door that said, please bury me in these clothes. They had not seen this lady for 5 days. I'm like, I know where she's at. So I kick in the door, and she's not there. She had actually went to a assisted living home. So I had to put their door back together before the family. So I'm zipping in screws and nails and stuff. But in that case, let's say in that case, I'm not getting an answer. Let's say someone was sleeping in there, correct? I'm a law enforcement officer. I kick in the door. They believe that I'm just forcing my way into the home. And stop me if I'm wrong. Under that statute, they would be able to defend that. And so that puts a little gray area in it for us. I'm not against it. I'm just saying it's something that I got it through my head now. Trust me. I'm thinking about that because I've heard people talk about it. Or same in the vehicle. It applies in the vehicle too, I believe, as the definition for a peace officer too, on the stand your ground.
Well, the Castle Doctrine does that,
right?
But
right.
But this Senate Bill 1 was really addressing your home, and it was really law enforcement. It was law enforcement's unlawful entry into the home, and that was the term that the Supreme Court ruled. And I was kind of curious that they used the word unlawful entry, and so that's what we was trying to define.
Right.
And during testimony, and there was a collective group of senators and House members that held the hearing in the Senate chambers because there was such a large turnout. Most of the people there were from law enforcement, and a lot of the testimony from law enforcement admitted that it was a perception problem, not that the law was written wrong, but it was just a perception that was against law enforcement. But it really wasn't. It was really I think a well-written law, and it does allow law enforcement on exigent circumstances, if they have reason to suspicion that somebody's destroyed evidence, that they can come in. There are certain designations that allows law enforcement to come into a home, and if a law enforcement is in there, what it does for the homeowner, that if at some point you feel that the law enforcement officer is operating outside the scope of his duties, or if he's threatening you or somebody in your family, then you have the ability to use defense against that. I think we also talked about you should use every reasonable ability to remove yourself from that contact if you can. But if you find yourself cornered back where there's no other place to go, and that circumstances arises, then you have that ability to use that. And one of the things that was brought up during testimony was there were instances that's been documented where law enforcement were violating their duty. And it happens. I mean, it's in every career. There's people that are outside the scope of what is lawful for them. And so that was presented, and that's why when we hear that people say, well, why would anybody want to use a gun against a cop? Well, there are circumstances that happens. It's documented. It's history. And in fact, I think we just had something recently where this one guy was bumping these cars, or either using a blue light, they suspect, was somebody enticing people to stop, and this guy was killing them. He shot several people, killed them. And they think he might have been trying to pose as a cop. So those are just enough instances that it happens that puts doubts in people's minds as to, is this legitimate? Is this a real cop? I don't know if you can buy badges, you can get uniforms, you can make yourself look pretty authentic. So because of this question out here, we also have to keep in mind we've got to have a protection from the citizen, or for the citizen, that we don't have it set up for their home. Their home is their camp, so it is their sanctuary. And for the legislature, that was a very difficult bill to work through. I mean, we was getting it from both ends. There was folks back home that said, we want our defense, we want to be able to protect our home, and there was people in law enforcement and their families. I was getting letters from wives that says, this is a cop killer bill, and thank you for you'll have blood on your hands for voting for it. And so emotions were running high as well. But
that wasn't my wife.
That did have a few letters from wives that go for it.
I'm a sniper. I don't have to go in your house.
But anyway, it's again, it points out on legislation how critical it is. And again, on my perspective, being here today, is on laws. I'm very cautious when we move ahead. I don't really just jump in and vote for or against the bill. I try to read these measures. I try to understand exactly what the intent is and what the full outcome is. What's beyond our headlights? What is it that this law will result in that somebody hasn't thought of yet? What repercussions might this law bring about? So I'm not ready to sign on to a bill or against it unless I know full well what that bill is going to do. I try to anyway.
Hey, I want to thank you. I've learned a lot today. I have to go coach a girls' swim team. I'd rather stay here, but that's just how it's going to work out. No offense, ladies. It's just a whole different environment. I have daughters. That's how that rolls. So I thank you. I thank you for having the opportunity. I actually learned a lot, and I didn't get charged $125 an hour. They're great guys. And I'm sorry for having to leave, but thank you guys.
Oh, yeah. Now that the cop's gone, we can open up.
I'll tell you the rest about sitting up on this, man.
All the big jokes are coming.